Matter of Stephen Watkins versus Richard McLean, Roxanne McLean, Chester and A. Gum Trust, Jane Felchak, Jerome Felchak, Anthony Selmer, Carol Westcott, Sandy Paws Cottage LLC, Cheryl Redmond, Peter Pinnell, James Wolfe, Gail Wolfe, Richard Panchek, Robert Harris, Benedict Wells, Katana Maribel, Amanda Ritter, Michael Hayish, Thomas Levinsky, Deborah Levinsky, Catherine M. Arnosky Trust, William Mellar, Nancy Mellar, Elizabeth Nemo, Dale Fox, Gary Fox, Aaron Murphy, Leland Kennedy, Betsy Kennedy, William Batcher, Schatz Family Trust, William Carehurt, Christina Carehurt, Joanna Neester Dudek, Edward Dudek, Sally Berghauser, Lisa Smith, Beth Dupree, Donald Dupree, John Warren, Devon Warren, Richard Greaves, Kurt Locke, Janet Locke, Philip and Judith Zanotti Trust, Brenda Stahl, Benita Dunstan, Warren Wilson, Jacqueline Wilson, Mary Furzo Trust, Martin Compton, Martha Compton, Dirk Steinert, Patricia Steinert, Kathleen Brooks, Obert L. Birch, Larry McDonald, Stacy McDonald, Pavlina Petrovsky, Slavko Petrovsky, John Orvis, Valerie Rushing, Jovo Serafimowski, Maliva Serafimowski, Linda Karsh, Lois Batcher, Robert DeCane, Linda DeCane, Lisa Cressy, Anthony Cressy, Richard Piazza, Mira Piazza, Kenneth A. Craig Jr. Trust, Matthew Sigler, Kathleen Pentelis, Kenneth Pentelis, Leo Messick, Tanya Messick, Gary Kuhn, Susan Kuhn, Kyle Burton, Robert Deachin, Larry Swark, Mary Swark, Dennis Decker, Jeannie Decker. I listed those names off on purpose. Are there any individuals I've mentioned that are in the courtroom this morning? No response. Appearing on behalf of Stephen E. Watkins in this matter is Attorney Jacob N. Whitty. Mr. Whitty, you may proceed, sir.
Yeah, Your Honor, I think the basis for our relief is set forth pretty comprehensively in the brief that we filed. Unless you have any specific questions about what we're requesting, I think I would just rest on the pleadings in this case.
All right, well, I've read the pleadings. What are you asking for, sir?
Your Honor, we are requesting a default judgment and summary disposition in favor of my client, Steve Watkins. So this is an adverse possession case. It arises out of an 8-foot strip of land that is adjacent to my client's property in I think, 1970. A deed conveying lot 60 to a predecessor of my client's for some unspecified reason excluded 8 feet. I think that was intended to be used by residents of the subdivision as tenants in common, but there was no other conveyance aside from just excluding it from the deed that was sent to my client. The plat was never amended to reflect that change, and since he took ownership of lot 60 in 2001, he has used that 8-foot strip of land consistent with the elements of adverse possession, which we explain in our brief. And the lawsuit that we filed was against all of the inhabitants of Oak Point, which was 88 individuals and entities. Of those, 85 were successfully served. 82 of them were defaulted. 3 responded, but ultimately did not dispute any of our claims. That would include the McDonald's, who filed a stipulation, and that I believe was through attorney Larry Cole, consenting to the relief that we're seeking. The only other defendant who responded was the Aronsky Trust, and in essence, that response said there's no dispute of the facts in the complaint, and they didn't want to be involved. The 3 defendants remaining that we were unable to serve were voluntarily dismissed from the lawsuit, so we're not seeking any relief against them. It's just against the 85 defendants who were named in this suit and were served and were either defaulted or stipulated to the relief that we're seeking. And in terms of the relief that we're seeking, Your Honor, it's just an order quieting title to that 8-foot strip of land to plaintiff Steve Watkins and a release of claims by all of the 85 defendants that I discussed earlier. We attached a proposed exhibit, or excuse me, a proposed order as Exhibit 1 with our motion. You should have that in front of you now.
All right, thank you.
Yes, Your
Again,
Honor.
is there any individual here that is subject to this lawsuit that I've named just a moment ago? And I hear no response. Based upon that, the court has reviewed the pleadings, and this is also a motion for summary disposition under C10, under 2.116 C10. And under C10, the test is the factual sufficiency of the complaint to determine whether there's any genuine issues to material fact. The evidence is considered in light most favorable to the non-moving parties. That would be the 85 defendants that are involved in this matter. The moving party is the initial burden of supporting its position, whether it be by affidavit, deposition, admission, or other documentary evidence, citing the Neubacher case at 205 Mishap 418. It's a 1984 case. The party opposing the motion then has the burden of showing any evidentiary material that a genuine issue of material fact exists. A genuine issue of material fact does exist when, given the benefit of reasonable doubt to the opposing party, it leaves open an issue upon which reasonable minds might differ. That's citing the West versus General Motors case, 469 Mich 177, a 2003 case. After my review of the pleadings that have been filed in this case, this is a claim of adverse possession. The elements of adverse possession include, for a period of 15 years, the possession of the property was open, continuous, exclusive, adverse, and notorious. There's been no evidence to indicate the contrary. As a result, the court finds that there's no genuine issues to material fact in this case. And as a result, summary disposition under C10 is granted to the plaintiff in this matter. And as a result, the decision of the court quiets title of that 8-foot strip to Mr. Watkins. An order has been provided in the file. The court will grab that order, execute the order, and we will send you a copy of that, Mr. Whitty. Anything
Thank you
else,
very much,
sir?
Your Honor. Nothing further.
All right, thank you. Have a great holiday.
Thank you, Your Honor. You as well.
This is Mr. Odell's motion regarding taxes, claiming exemptions. Mr. Odell is present. He's in pro se, which means he represents himself. Ms. Parker is also present in the courtroom representing herself. Mr. Odell, you may proceed, sir. What are you requesting? Oh, I need to place you both under oath. I apologize. Would you both please raise your right hand?
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
And Mr. Odell, do I have this correct? This is a motion exclusively regarding tax exemptions, correct?
Yes.
Go ahead, sir.
So past year has been a whirlwind of just confusion concerning the taxes. To my knowledge, this past year was my year to claim our daughter on taxes. I went through the front of the court to confirm it. They confirmed, yes, it was my year to claim her. So I went to a tax advisor to fill out my taxes. After he finished trying to put them through electronically, it was denied, stating that our daughter had already been claimed for the year. So he advised us to try mailing them in, go through the IRS. At that time, I contacted Jade. She initially claimed that it was her year to file and claim Ruby for taxes. And later on in the year, as time went on, no contact from the IRS. I contacted Jade again. She says it was my year to claim her, and that she didn't claim her. Finally, we can come down to about 2 months ago. Talking to my tax advisor, he said, well, just file electronically. So I did, and by doing that, I lost out on $3,064 from the IRS. So, I mean, I'd like to be reimbursed the difference that I lost out on, not being able to claim.
I don't want you to name the child, but how old is the child right now?
5.
Five, okay.
I also believe this has happened past 2 times I was supposed to claim her, but I'm not going to go after that.
Ms. Parker, your response?
Your Honor, I never claimed our daughter for 2023 tax returns, and I have proof here, right here in my tax returns. And on page 2, if I could show this to you, can I?
Just.
Oh, okay, on page 2.
You can give me the information.
It says tax and credits, and on line 19, child tax credit or credit of other dependents, and it is blank. I never claimed her. I also have a letter from my tax preparer, and she wrote in it that I did not claim her for 2023 taxes, and I don't claim her on odd number years. That is Mr. Odell's, and I get the even, so I did not claim her.
Okay,
It's
well,
just simple.
and Ms. Schultz can help me on this, but there are 2 types of exemptions here. There's the standard exemption, which you're referring to, but there's also the care credit. Ms. Schultz, can you shed some light on this, please?
Right. And my understanding is, Parker had contacted the front of the court office and provided a 1-page summary of the tax document that she's referencing. And the document that was provided to our office, it is not marked that she was claiming the child care credit, but the documentation I received did not reflect whether or not dependent exemption was claimed.
Do you have that page?
Yeah, I have everything.
Any idea, Ms. Schultz, what the tax statement was?
It was listed on the first page.
Can I bring this?
Sure. If you want to show it first to Mr. Odell.
What's a care credit?
Ms. Schultz.
The care credit, my understanding is it's an additional amount allowed under the IRS code based on residency of the child, but it is essentially dependent exemption.
And the dependent exemption would be the higher. Okay. Thank you. Any objection to me looking at this, sir?
No.
Okay, thank you. It is marked. Head of household. You did claim.
For the I had a household credit, but I'm the dominant. I have primary domicile.
I understand that, but this order trumps that. You agreed when the judgment was entered on June 1 of 21. Is hereby further ordered and adjudged that for income tax purposes, the party shall alternate the minor child on a year-to-year basis. The plaintiff claiming said child in the even-numbered years and the defendant claiming said child in the odd-numbered years. And according to this tax return, you claimed as head of household, and as a result of that, he loses out on credit. Now, despite the fact that you're saying, well, wait, the child's with me primarily, I understand that. That is the IRS code. The problem, though, is you agreed that you would alternate that on a year-to-year basis. So you did claim that.
But I didn't get the child tax credit, and he still was able to get that. That's what my tax lady said. She said that he could still get the child tax credit, and by law, that it doesn't matter. Because I said, well,
That's the problem. As soon as you said it, by law, but your tax preparer probably is not aware of this provision.
I told her, though, I said that I'm like, we have 60-40, and every other year he gets to claim her. And she said that we weren't breaking any rules because this is.
Well, I'm not saying anyone's breaking any rules, but the spirit of the income tax exemption order that this court has seen for over 10 years, and even in private practice, when I was representing clients just like each of you in this, when you enter this provision, that covers everything, not just how many days per year the child's with a particular parent. So I'm not saying you did anything wrong or illegal. That's not what I'm saying. But what I am saying is he did not receive the benefit for that particular year. So
Can I say something, Your Honor?
sure, go ahead.
I was worried about that for this issue. And I said, would he still be able, even though I'm getting the household credit, would he still be able to claim her for the child tax credit? And she said, yes. She said, I do it all the time. I do it with, divorced parents all the time, split up parents all the time. So he'll still get his credit.
But
She said it's tricky, but it can be done.
But if you compare the credits, one is much larger than the other, in my experience. So it's not that you did anything malicious. I'm not finding that at all.
Yeah.
You're relying upon professionals, and I understand that, but it appears to the court that the tax preparer was not aware of the specific provision as to what it encompasses. So I find in this matter that indeed Mr. Odell lost out on the tax credit for this particular year, and I will order, rather than requiring someone to haul off and just hand you a check for $3,064, for next year, and for that year only, father may claim as head of household as well as the exemption.
So both of us we didn't get the child care credit. I was wanting to have it be where I get the taxes every year because he has 2 other children that he can claim on, and she's my only daughter.
Oh, I understand that, but I wish you, then in that case, you should not have entered into this agreement back in 21.
Yeah.
So, and let's see, who was represented? Actually, both parties were represented in this case. Mr. Odell was represented by Mr. Schroep, and you had Ms. Salins. So that's what I'm ordering for the 24 tax year only. Dad claims head of household as well as the credit, other credit, and then continue the alternating from there.
So he gets her 2 years in a row then?
Yeah, just like you did this past year.
I didn't get the child tax credit.
Right.
Can't he just claim the household and then I get the child tax credit?
How about that, sir?
No. I feel like I have not received my claim for the child any year that I was able to claim.
Well, I thought I just heard you say there were previous years you didn't receive it and you weren't going to worry about it.
I'm not going to go after it. But I think we made an agreement to begin with, and
We made a lot of.
I think we should follow it.
We made a lot of agreements, Your Honor, and I have been so nice and understanding, and I give everything to him like that. I've been so like the best co-parent ever, I feel. Like giving him whatever, to make it the best for Ruby and everything. Or I'm sorry, I shouldn't say her name, but for the best for our daughter. And he makes so much more money than I do. Like it's a lot more. Plus he has 2 other children that he can claim. I just feel like for future, I should be able to get I'm a single mom. I don't have an extra income coming in and all that.
I fully understand that, but if the court were to break the agreement, that'd be just like the court coming in and saying, well, we're not going to enforce a valid contract. This is a valid contract. And for me to come in as a judge and say, you know what, forget the contract. I don't care if you negotiated this in 21. We're just going to do what we want to do. There'd be no contracts. So, and again, no disrespect. I understand where you're coming from. I understand where both parties are coming from. So did you get any credit for this year other than
For the child?
Yes.
No.
Okay. Then I have to follow the previous agreement of the parties. He gets to claim for this next tax year only. And we alternate from that year afterward according to the order. That's what we do. Thank you, everyone. Off the rest. This is Mr. Hamill's motion regarding parenting time. Mr. Hamill's present, represented by Attorney Gregory H. Bringard. Ms. Ruth is present, represented by Attorney Dennis W. Reed. Mitchell Holdwick from the friend of the court's office appears via the Zoom application. The court had a brief sidebar with counsel. Ms. Schultz was involved with that too regarding the status of this matter, and we'll hear the motion at this time. Mr. Bringard, you may proceed.
Thank you. Your Honor, first off, I believe we have an agreement as far as the Christmas visitation with my client. It would be the Sunday after Christmas, the 29th, from 11 to 6. There would be, Emma would go to her paternal grandmother's house. My client
Please don't use the child.
Yes, I'm sorry, Judge. The minor child would go to my client's mother's house for parenting time, and it would be supervised, obviously, there. Your Honor, so I guess that's our agreement for that part of it. Now, we're also, in our motion, Your Honor,
Well, let's cover it if we have a stipulation first.
Yes.
Mr. Reed, do you agree with that, sir, on behalf of the client?
Yes, the only additional item is that my client will actually be the party delivering the child and picking up the child. I'm hoping that'll make it go a little smoother.
And I believe that was stated in sidebar too.
Yeah, and so it'll be the 29th, 11 a.m. to 6 p.m. as supervised and at the location represented by Mr. Ritter.
Let's place both parties under oath regarding that stipulation. Well, please raise your right hand.
Oh, me too?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I'm sorry, I didn't hear you.
I do.
Okay, thank you. Mr. Bringard, you want to cover the stipulation?
Ethan, you heard the stipulation put on the record regarding parenting time on the 29th from 11 to 6 for your mother and child, correct?
Yes, sir.
And that would be at your mother's home where you would be present, correct?
Yes, sir.
And you're in agreement with that, is that true?
Yes, sir.
Do you want me to also ask?
I'll ask Mr. Reed. Mr. Reed, you want to address that with your clients?
Yes, Alyssa, you've heard the settlement has placed on the record regarding Christmas visitation.
Yes.
And is that your agreement?
Yes.
Thank you. Go ahead, Mr. Reed.
Thank you, Your Honor. Your Honor, as the court knows, there's an order entered in this case back in July 26th of 2021. And in our motion, we state that my client's parenting time was suspended at that time. And the order also further states that the front of the court shall submit an ex parte order for reinstatement of defendant's parenting time upon receipt of notification from Child Protective Services and the investigation is completed, or defendant may petition the court for redetermination of that issue, whichever occurs first. It's my understanding that the Child Protective Services investigation has been closed. My client, as part of a criminal case involving a different child, he was put on probation. He has satisfactorily completed that probation. In fact, finished early through this court, and he's been discharged from probation. So apparently he did well while he was on probation, or he wouldn't have been discharged earlier. Your Honor, what we're asking for, and I know that the friend of the court here is doing an investigative report, and that will be provided to all the parties, but that isn't completed yet, is my understanding. What we're asking for today, though, is at least in the interim, until we can get back to court and address the issues in that report and maybe some issues with a counselor, that my client be granted supervised parenting time every other weekend at in the supervised parenting time can occur at the paternal grandmother's house, grandparents' house. And we're requesting that it be from Friday till Sunday, overnight. And that's what we're requesting until we have the report and we can come back, and then we'll see where we're at that point. But my client, to deprive him of seeing his minor child after the court order specifically addresses some issues, the Child Protective Services investigation, which is complete. He's completed probation. He wants to see his child. That's what he wants to do. So we're here before the court today to at least get supervised until we can determine through evidentiary hearings, consent, whatever, that what's going to happen permanently going forward. So we're requesting that from the court today. We believe that that's appropriate. It's in the best interest of the child. Every other weekend, supervised, we understand that. So that's what we're requesting from the court today. The last time my client saw his child was in October. He was in court on, last time in August, apparently coming in October, saw his child. And so he still hasn't seen her since then. So he wants to see his child. He wants to do it on a continuous basis. And I think that's best for the minor child. It's best for her because she gets to see her father. She gets to see the father side of the family. And it's my understanding that she has a good relationship with my client's extended family. So we think that's appropriate in this case. That's what we're asking for today.
Mr. Bringard, though, you're aware that we are awaiting a report from the counselors relative to this.
That's my understanding.
And you've not received anything back from anyone regarding that yet, have you?
I haven't received a report. Mr. Reed did provide me with some documentation that he got from the counselor, but it's not a recommendation or a report from the counselor. But it was some documents from where the child goes to counseling.
Okay.
Thank you.
Mr. Reed, your response.
Thank you, Judge.
We'll start at the end of the argument here. I did receive, and unfortunately it took some time to get it. I received short notice of this motion and got on it literally the day I received it, which was last Friday. My client did as well. And we had some communication difficulties with the counseling service, but midweek we got through that, and I was able then to, unfortunately it didn't come until yesterday afternoon, and as soon as I got it, I sent it to Ms. Schultz by email, and I faxed it over to Mr. Bringard as well. I didn't file a copy with the court because it's confidential and contains a lot of information in there that I didn't think should be in an open file in court. But the child has been going to the psychological services. She's had 7 appointments. One of them, I believe the 17th, so just this week was her most recent appointment. She has been diagnosed as to what she's suffering from by the counselor. She has weekly appointments scheduled. Her next appointment, we've arranged it, and it was done intentionally for that reason, for December 27th. So just a couple of days after Christmas. In our response that we filed with the court, we actually proposed some type of Christmas visit in there. We didn't know what his family's schedule was or when they were doing things, and so we left it pretty open. But my client did propose something in that response. And then we anticipated it was going to be before the 27th, but it isn't, so it's going to be after. But the child is going to be going to her next session on the 27th to address the upcoming visit that we've agreed to with father. As soon as they could get her back in is January 10th, though I had hoped for a session the following week, but again, with the holiday, I wasn't able to accomplish it. So December 27th and January 10th are the next two appointments for this child. I did speak personally with the counselor yesterday on the phone. And in essence, she is not prepared to give a recommendation just yet. She wants to do more sessions with her, meaning the child, and wants to address specifically the visitation issue. Is one of the issues she's outlined in her report is being discussed with the child, so we know we're focused on the issue. And I'm hoping that, and that's why my client proposed this, is that we have a good visit on the 29th, everything goes well, and have a meeting with the counselor just as quick as we can, which is January 10th. And see at that point in time if the counselor is prepared to make some type of recommendation on interim visits, supervised visits with father, I would imagine. That's what I'm asking the court to do, we'll have the one visit on the 29th, have a couple of sessions, and then if need be, we can come back here. But at least, we'll have some control on it. I did look at the calendar to see what day of the week the 10th is of January, but I imagine it's around a Monday or Tuesday.
It's a Friday.
Oh, coincidentally, there we go. So we could have a hearing here the following Friday, if the court's available on January 17th, and hopefully have the counselor present, and at least, if not by Zoom, at least to be able to testify and update the court on what's going on here and what her recommendation is on this. See, and this is one of the things that I'm not sure counsel is appreciating. This isn't that there's been incidents at grandmother's house. No one has said that. No one has said that. And you can look at our responses that we filed with the court. No one is saying anything. But what's happening here is because the visits, and I guess it's the child's eyes, it's forced. She must go visit with her father. She's suffering from what I consider to be fairly extreme anxiety, as I've represented to the court in writing and in this courtroom. She is throwing up before a visit. She is not sleeping. She wants to sleep with her mother. She hears a vehicle on the road and she thinks it's her father coming to get her. I mean, it's just, her grades in school just plummeted right after dad filed his motion. She was aware she was going to have to go for visitation. Her grades just went right down. I have them actually showing it. Since the court actually entered a second court order, which Mr. Ferngard did in reference to the court dated November 5th, 2024, which also resuspended father's visitation and ordered the child into counseling. Since the visits have ceased, my client represents to me that the child seems to be in real good spirits. Her anxiety is lower. She's not experiencing what she was experiencing prior to that. And her grades have come back up, which is good. And so it seems that this dip occurred when there was the stress of having to go for a forced visit with the father. It seems to really affect the child. That's really the issue that we're concerned about, is what's the effects it's having upon this child. And the father just apparently doesn't seem to care, at least enough. I see nothing to be gained here, really, by forcing regular weekend visitation with this child to go from really nothing to a full weekend. I think is really not a good idea. And I think we all should just slow down a little bit on this and then reconvene at this on the 17th and see where things are at that point in time and moving ahead. I'm hoping perhaps Ms. Schultz can enlighten us on that. If we might have in front of the court's recommendation by then as well.
That's what I'm going to find out in just a moment.
Yeah, I'll shut up here and you can do that, but
No, you don't
that's
shut up,
okay.
but it's not
No,
what I'm saying.
Judge, yeah, I tend to ramble, but if Mr. Bringard, I understand, has a list of additional people he wants the front of the court to interview. I thought he said 4, maybe 5. I don't know if that even can be done during the holidays here, but I imagine in early January could. And then maybe they would have a report, if not in writing, at least orally, that they could present to the court on 17th. I think it'd be a smarter way to handle this thing, and I'll provide this information to the therapist, and so she'll see that she's going to be happy to make a recommendation of some type if she can within that time period. She also said that she may get to the point where she may want to speak with father privately, which I encouraged her to do. I thought it was a good idea to get him in there as well, and maybe that could occur after the procedure sometime. So that's where we are with it.
Thank you, Mr. Reed. Mr. Bringard, any final comments, please? Since it's your meeting.
Yes, Your Honor, I would, and I guess I'll maybe walk down to the front of the court after this hearing and give them the name and phone number of the people who I'd like them to talk to. Would that be the proper way to do that?
Mr. Holdwick, you're doing the investigation, sir. How do you want that handled?
Yes, Your Honor, that's fine with the name and relationship to the parties or child with phone number. So at least I have an idea and I can do that. But just so everyone is aware, that may not happen until possibly the second full week in January. I am out of the office until after the first of the year, and that first full week in January, as the court knows, we have a contested divorce trial that I am involved in with the custody investigation. So soonest I could really crack down on this would be the 13th.
And we're going to have a hearing when the courthouse is closed because we have to proceed on that case. It's crazy. We're going to the Expo Center. If anyone's interested in going to the Expo Center for a court hearing, join us.
Big one there. So I'll do that, Judge, but just to get back to my motion real quick, I just think that, you know, to delay and things like that, Mr. Reed has actually admitted there's no allegations against my client's mother that there's been any issues when the minor child has been there. So that's what we're proposing. I don't know why it would be stressful or anything like that to the minor child if she's never had any issues at her grandparents' house and my client is there, somebody else is there. And I think that's the proper way to proceed forward. And then it really gives the therapist an idea that, oh, she is visiting dad's family, and then she can ask her about that. If we just don't allow that visitation to take place, what happens is the therapist really doesn't have all the information. She doesn't have the information about how things are going when she is visiting dad or when she's visiting dad's family. So I think it's more appropriate, the therapist is going to make a recommendation, that recommendation include visitation with father, and then she can say, well, this is the problem with visitation with father, or visitation is going good. But at least she has a base of reference, Judge, and that's why I think it's more appropriate to get the supervised parenting time going. Thank you.
Thank you, Mr. Bringard. Mr. Holwick, do you have any idea if you have the opportunity to review or interview these other individuals when a report could be prepared? I'm not trying to put you on the spot, but
to give you a solid date, Your Honor, I mean, that's going to be a tough one. I just met with the parties beginning of December, and then it was hearings and other interviews after that. I can do my best to try to get it done as quickly and as quickly as I can after talking to both parties and any additional individuals that that counsel would like me to speak with. I do also have to schedule a time yet to go and visit the school and talk to a few other individuals as well.
okay. Thank you. All right, this is the defendant's motion to reintroduce essentially a parenting time. The request is alternate weekends supervised by the father's, by paternal grandmother. The court after the October hearing, along with Mr. Holdwick, had the opportunity to meet with the minor child. I promised the minor child I would not share the information with anyone regarding what she said. I'm standing by that. And the reason I'm doing that is the last thing I want to do is place a child on the witness stand facing both mom and dad and testify. And that's how I feel about it, because the utmost interest of the court is the best interest of the child. That's what this comes down to. Now, the court takes judicial notice of its other files, of which was referenced by Mr. Bringard, that is the criminal proceeding that the defendant in that case pled and was sanctioned as a result. Probation is over, successfully completed. The child involved was not the child in question regarding that matter, but I can understand how it can have effect on the other children as well. So, last visit was in October. Mr. Reed had brought to the court's attention how that visit essentially went, how the child felt, and understand that as well. At this point, what I'm not hearing is, despite 7 visits, there's nothing in this record from the therapist saying, no visit until I make a report. There's nothing. If there is an issue, I would trust the therapist would say, look, don't do anything, call a timeout. Let's look at this after I had a little more time, and I'm not hearing that. So that bodes in favor of father. But on the flip side, to go immediately to overnights, alternate weekends, I think would be too much. And also too, it was considered a quote unquote forced visit, but yet the parties are stipulating to the 6-hour visit over the Christmas break, which I greatly appreciate on behalf of the child, because both parents are trying to do what's right. And so I give both parents credit for that, but it begs the question, that's kind of forced too. If it's forced, then why not any further? So this is what the court is going to do in the interim until we have our hearing. Once the report is prepared, the court is going to order, at this point, obviously the stipulation. And after that, it can be every weekend, 6 hours, paternal grandmother supervises. Paternal grandmother does not leave the side of the child for the 6-hour visit. It can occur on Saturdays or Sundays, however the parties wish to agree to it. If the parties want to agree regarding transportation, that's fine. If neither party agrees to transportation, the party wishing to have the child picks up the child. The party having the child returned to return to their household, mom would pick up the child and take the child back, unless there's an agreement otherwise. So that will begin after the Christmas visit, and that will continue for 6 hours, either Saturdays or Sundays, supervised until we have the hearing. Mr. Bringard, would you please prepare the order?
I will, Judge. Just one question. So Saturday or Sunday, so the parents will just have to agree on that then? Is that
Yes.
Okay.
Yes. Because I don't know what the parents' work schedule is. I'm trying to be accommodating to both.
Okay, yes. Thank you, sir.
And so the court will not have us back on January 17th then?
Well, if you notice it, notice it up. Yeah, you can, we can do it on the 17th. I'm hoping we'll at least have a therapist report. Let's just do that. Let's do it on the 17th, 9 a.m. I don't anticipate Mr. Holdwick having the report completed, and I can understand why. Then we'll see how things are going. So I'll do that. Ms. Schultz?
Is the court ordering a default time and date if the parties are unable to reach an agreement?
Oh, that's probably a good idea. What is the Christmas visit time?
11 to 6. So maybe a 12 to 6 either.
Noon to 6 p.m.
For the going forward.
Okay, Mr. Reed?
My client would prefer Sundays, Judge, rather than Saturdays.
That work?
That's worse for my client.
Okay, Sundays, does noon to 6 work, Mr. Reed, on behalf?
Yes.
Okay, well, let's talk about transportation.
I think it's just, I didn't talk with my client about it here, but I'm thinking maybe just let my client provide the transportation. I don't want to send
She's
it.
nodding, I just.
Is that okay?
Yeah.
Yeah.
Your client. Mr.
Yeah,
Reed.
no, that's okay. I just hadn't had a chance to chat with her, but it's the same reasons that we're proposing, and we agreed, I should say, that she provide transportation on the 29th. I don't want a situation arising where perhaps the grandmother shows up and the child refuses to go and get in the car. I mean, it's a little older child here. We're not talking about an infant.
No.
And I'm thinking if my client is the one doing the transporting, we can avoid that scenario.
I'm assuming, Mr. Briggs,
We agree with that, yes.
okay. And understand though, this is the court not trying to just to test this and put the child into a maze here to figure out what's going on. I mean, if I heard something differently from the therapist saying no, or if there was no agreement regarding the Christmas holiday, I might think differently, but let's see how this goes. We'll see.
And I had hoped to acquire that yesterday, Judge, but
No, it's not your fault. You did your due diligence. So we'll see each other on the 17th at 9 a.m.
thank you, Judge.
Have a great holiday. Ms. Seaver's motion regarding taxes, she appears by the Zoom application. Court again calls Demetrius T. Epps Sr. No response. The court did not get a response previously. The court inquired of Ms. McNames, who is operating the Zoom platform, whether or not Mr. Epps has checked in. He has not. Ms. Seaver, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. Ms. Seaver, you were requesting what was in a similar case we just had a moment ago regarding tax exemptions, correct?
Correct.
And you acknowledge that on September 20th of 2022, there was a hearing where it is ordered that for purposes of local, state, and federal income taxes, you shall claim the child as your dependent during the even-numbered years and Mr. Epps on the odd-numbered years.
Correct.
Okay. I apologize, I'm not on the screen. Okay. And that was agreed to, correct?
Correct.
But you wish to change that,
I do.
okay? And your reasoning behind it is that the non-custodial parent only has the minor child about 92 days a year plus split holidays every other year. And
Yes.
the child obviously primarily resides with you.
Yes.
Okay. Well, again, and this was in the previous hearing, and I don't want to be the bearer of bad news, but when parties agree to certain things and the court orders it, that's essentially a contract which the parties agree to, and the court is bound to follow the agreement. If both parties agree to modifying that and it's placed on the record, the court will gladly modify it. But here, and again, Mr. Epps is not here to address this. He should be here, but
And he is aware of the court today because he texted me on Sunday to receive the paperwork and
okay.
he still didn't show up. So
Sure, I believe me, I understand that there are many cases where the individuals don't show, but is there any other reason other than what you stated in your pleadings?
well, he does have 5 children, one including mine. I feel like with him being with the other baby and having 4 children with her, I feel like it would only be fair for me with 1 child as a single mom to be able to claim her.
All right, Ms. Sebra, this is the same matter that the court just heard a moment ago, and I feel terrible about it because common sense wise, it would make sense that, look, you can claim 4 and I can claim 1. It's a wash, we move on. But there's an agreement reached between the parties, and we normally don't see those in DS files, but it's in this one, and I have to follow the order that has been presented. Understand your argument, but because you both agreed to it, absent a stipulation by father or some other compelling reason, the court cannot grant the relief you've requested. I'm sorry.
No problem.
Sorry. Thank you. That'll conclude the proceedings. You're free to go. This is the defendant's motion to enforce judgment of divorce. Defendant, Mr. Kuhn, is present. He's in pro se representing himself. Ms. Jeffers appears in pro se representing herself. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. This is, as I stated, Mr. Kuhn's motion to enforce judgment. His motion that he filed with the court involves a provision within the judgment which indicates that the plaintiff, Ms. Jeffers, is given 180 days to refinance the home. According to Mr. Kuhn, Ms. Jeffers has not yet done that, and it's been 2 years. There's a past due mortgage, obviously potentially affecting his credit. And Mr. Kuhn, you're requesting that the home be sold, correct?
Sold, taken out of my name before it goes to foreclosure, whatever the court finds best to deal with this matter.
How much, what do we have for an arrearage here? How much is still owing on past?
$84.
$84?
I'm already in actually a payment arrangement and it's not affecting my credit. So I'm not quite sure how it's affecting his, as my payment arrangement took it out of the negative.
Okay.
Your Honor, I have been in contact with Neighborhood Mortgage Solutions, the company that owns the mortgage. I brought statements with me today, and as of December 16th, which was 4 days ago, there was a past due balance of $2,125.23 and a due date with a full amount due on the 1st of January of $2,864.50.
Okay. You want to show that to Ms. Jeffers?
So my payments are $723.84 a month. So the total is $4,338 for the 6 months that I've been in the payment plan. And so far total I've paid, and I brought the receipts, $4,253.65, leaving $84.35. And my last payment was the 19th, and I was also in contact with Neighborhood Mortgage Solution. I did.
Show that to Mr. Kuhn? So, Ms. Jeffers, what's the status of having the home refinanced?
So I actually have an appointment on the 14th to have it refinanced. I took his name off the accounts and I was inexperienced. I didn't realize I then had to go through the company as well for refinancing. I thought taking his name off the account made him unresponsible.
When you say the account, the money account or the deed?
Yes.
Which one?
Both. So we did our mortgage through Team One Credit Union, and he was on we did the mortgage together. And then in order to make that easier, I also put him on my checking account that I had there. So I removed him from my checking account and the account that we did our mortgage.
So when did you remove Mr. Kuhn from the mortgage?
Maybe a week after we got divorced in 2022.
But according to his information, he's still on the hook.
But that's Neighborhood Mortgage Solutions.
And they own the mortgage. We applied for it at Team One, and they take the mortgage, and it goes through Neighborhood Mortgage Solutions, not through Team One Credit.
Correct. And what I'm saying is we started.
Ms. Jeffers, we'll have you both address the court.
Sorry.
Okay.
We started at Team One. We joined an account together at Team One. That was our starting point. So I took him off of that account. I did not take him off of the Neighborhood Mortgage Solution, and I didn't realize that until 6 months ago when I talked to him. He said that he had been in contact with the bank and he was told that he had been taken off. So may I please have my paper?
Yes.
So what is your appointment with the mortgage company to have this refi?
The 14th.
January 14th?
Yes. I made that as soon as I got the paper in the mail because I hadn't heard anything other than, yes, I talked to the bank and they said my name's not on it.
Okay. So, Ms. Jeffers, do you anticipate any problem getting the home refi?
No.
Okay, let's do this. Do you think you'll have an answer on the 14th?
I'm assuming. I had to print off all my papers and get my tax stuff, and it's an in-person appointment, so I'm assuming it'll be completely taken care of by the 14th.
All right, this is what I'd like to do in this matter. In order Judgment of divorce is very clear. Again, it seems like we're talking contract today, but you have to treat it as a contract. The judgment of divorce indicates that the property in question is awarded to the plaintiff, namely Ms. Jeffers, free and clear from any claim of the defendant, Mr. Kuhn. Plaintiff is to refinance the home within 6 months. That judgment was entered on November 17th of 2022. Clearly, it's well beyond the 6-month time frame. Ms. Jeffers reports to the court under oath that she has a meeting, an appointment on January 14th regarding the refi, and she believes she'll have an answer. As a result, the court will take the matter under advisement. We will meet again on January 24th at 9 a.m. If the home is refied, the court will deny the motion because the relief was provided to the defendant. If the home is not refied, the court will make its decision regarding the status of the home if the refi is not. You understand that, Ms. Jeffers?
Yes.
Mr. Kuhn, you
I
understand?
just have a couple questions here,
Go ahead.
because I have all these receipts right from the mortgage company. And according to the bank statements that she's brought and provided here, saying that she's making these payments, it says here that due on December 16th of 2020, when the statement was due, that there was a past due balance of $2,125.23. And according to her paperwork that she's brought, she has only made a payment of under $800. So it is definitely affecting my credit here.
Oh, I understand that. That's why if the refi is done by that January date, we're all set. That won't affect your credit. However, if it's not done, the court's going to take action on this.
Is the court able to take action and get me damages to my credit? I mean, this was a contract, like you stated before, Your Honor, and it should have been followed, and it clearly has not been. It's been neglected for over 2 years now.
Okay. And Mr. Kuhn, all I would suggest you do then is to file that motion asking for whatever damages you may be asking for, and the court will consider it. You may want to file, and I can't advise you. I can't provide legal advice. But I can tell you, it probably wouldn't be a bad idea to bring that motion for the 17th.
Okay, the 24th.
Or 24th, I'm sorry, the 24th. Thank you, Ms. Ashe. So that's where we'll leave it. Obviously, due diligence in getting this done. I don't want to affect anyone's credit rating. That's the last thing the court wants done. So we'll see you on the 24th then. Thank you both. This is Mr. Kuhn's motion relative to issue pertaining to the judgment, specifically the refinancing of the home. Both parties are present. They are in pro se. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. The court recalls previous hearing late last year regarding this matter. The court also recalls at that hearing, Ms. Jeffers had provided information to the court orally that apparently payments were made, something was being done relative to the refinance. Mr. Kuhn filed a motion for today indicating that nothing has been completed. Mr. Kuhn, what's going on here, sir?
Well, if I could, Your Honor, I have a letter here from Neighborhood Mortgage Solutions that handles the mortgage. In the letter, it states that I am still a co-borrower on the mortgage loan for the property address. They have not received a request for a payoff at all yet from the co-borrower. I've also brought a copy of the statement, which shows that my name is still on it, and also shows that the mortgage due February 1st of this year is for $2,140.66, which means that December, January, and February's mortgage payments still have not been made.
And as a result, you're requesting that the home be put up for sale.
I would just like to see this handled before the home goes into foreclosure and further damages my credit.
All right, thank you. Ms. Jeffers, your response.
I have a letter also from Neighborhood Mortgage Solutions saying I am approved and they do already have my check for the fines sent to refinance. However, he has never signed a quitclaim deed despite me asking him to, and they cannot move further until he signs it. So I brought it today to hope he would sign it so I can go further.
Well, what is the verification to indicate that payments are up to date and or the refinance is complete, other than what you stated?
I have this from who I met with that says that my principal loan amount for the remainder of the loan, 73,372, which I'm sure you'll agree is,
Ms. Jeffries, right here, please. Right here.
oh, sorry. For the loan term, 30 years, no closing cost refinance, 6.5% fixed, and then all underwriting conditions must be satisfied before the loan can close, including a quick claims deed, because they have my divorce decree, but they said they still need this. And I have to file it with the Register of Deeds before they can close.
So do you have any indication from the financer if the quitclaim deed is signed, when the refinance will be complete?
No, I can't. That's all they told me they were waiting for when I met with them on the 14th, and I actually called yesterday and made my January payment. So I'm just, or my December payment, so I'm just waiting on my January payment.
Are there payments in default currently?
Just January's, which is being paid this month.
Do you have any proof to indicate that the payments are up to date as opposed to Mr. Kuhn, who stated
If I can grab my
December,
phone, I
January,
do.
February have not been paid? You can grab your phone. You can show that. Mr. Kuhn, when you contacted the mortgage lender,
He said to show you.
when you contacted the mortgage lender regarding the payments not being made, when did you receive that info?
I called on Monday of this week, and they sent me the statement, which is dated for the 16th, knowing that our court date was gonna be today. I had them send me a letter again yesterday from a servicing agent that verifies that my name is still on the loan.
Okay, but relative to any payments that were not made, when you said December, January, and February not paid,
Yep, I have it right here.
when was that provided to you?
It's dated for the 16th of this month. So 5 days ago.
Oh, 5 days ago. When did you make the payment?
Yesterday. I have the payment confirmation, and it says that it was also paid December 18th, and it is caught up.
You want to show that to Mr. Kuhn?
Tried. He told me to show you.
Oh, well, I don't want to look at anything until Mr. Kuhn has had the opportunity to look at it first.
Do you want to see the payment I made yesterday for the amount I made?
Well, I can see here that it says that you made a payment January 6th, which covered November's payment.
I've been making 2 payments. I just made.
I mean, it does say that she made the payment, which, I mean, that's fine, but it still has not resolved the issue of.
Oh, I agree.
His name still is on it. I just need him to sign the quick claim deed.
Do you have any, because here's my concern. If I would require Mr. Kuhn to sign the quitclaim deed today, and then come to find out the payments are in default, his credit goes down the tubes. And I don't want that for him. I don't want that for you either.
No.
But do you have a letter or something from the mortgage company saying, all we need is this, and then we can refi?
I could get it. I've just been talking to him on the phone, and that's where it stood.
I'm going to give you 7 days to get the letter
Okay.
to the court. If you do not get the letter to the court within 7 days from today, then the court is going to we're going to schedule a hearing for next week. Both parties can appear by Zoom. Don't have to take time out of your schedule to be here. And if the letter is not in, the court is going to grant the relief. Mr. Kuhn, place it for sale, mutually agreed realtor, mutually agreed price. We have to get this off of, we need to get it moving, is what I'm saying. Okay, the hearing next week will be via Zoom at 8:30. Only reason for that is I'm continuing divorce trial next Friday. I don't have a civil docket. So appear via Zoom. Do you both have capability to dial in via Zoom?
I believe so.
All you need is a smartphone and the app, and it's real easy. They'll ask you for a meeting ID. It's our telephone number, 989-269-7112. No passcode, no nothing required. If you do get the letter, get a copy of it to Mr. Kuhn immediately.
How do I do that?
You can mail it to him. You can mail it to him, email it to him, I don't care. Send a courtesy copy to the court as well. And by doing that, I'll have it here and we can address it. But next week, this is going to be done. Any questions?
Your Honor, yes.
Mr. Kuhn? Yes.
About the second motion that was filed, then we will also be handling that next week. but-
Go ahead. Well, what's that second motion? Remind me.
The second motion was for the damages to the credit due to this lingering problem that was supposed to be resolved about 16 months ago.
Your credit rating did go down.
Oh, yes, sir. I have, Your Honor, I brought proof of that today.
Do you have any estimate regarding what the damages may be?
It's very hard to put a monetary value on credit score. However, I've looked into borrowing money, as far as, buying a new vehicle, and is looking at, on a 5-year auto loan that's going to cost me almost $7,000 in extra interest due to the 90 credit score points that I've lost. And I also know that Michigan drivers with lower credit scores pay a much higher premium on their auto insurance. And most studies I found conducted by Consumer Federation of America, they show that we will pay 263% more for car insurance than people with good credit scores. I mean, my premium this year alone has gone up $1,800 as a result of the credit score drop.
1,800?
Yes.
And you have proof of that you can provide to the court?
I can get it from my insurance agent, yes.
Brandon, email that to the court as well, or send it to the court. Send a courtesy copy to Ms. Jeffers. Okay, and then we'll address that as well.
All right.
Anything else?
Yep.
Back to Ms. Jeffers, anything as well. Nicole L. Kruger versus Anthony M. Spencer. This is Mr. Spencer's motion regarding parenting time. He appears by the Zoom application. Ms. Kruger appears in the courtroom. Will both parties please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you? Yes.
Yes.
I'm sorry, Mr. Spencer, did you say yes? Maybe.
Yes, sir.
Okay,
Yes.
thank you. I couldn't hear you. All right, Mr. Spencer, I've reviewed your motion. Before we proceed on this, we had a hearing a couple weeks ago.
Yes.
We're not going to do that again.
Okay.
This is a courtroom and one party speaks and the other party speaks. I'm not going to allow interruptions. This is your motion, and I want to hear your motion, and then the court will make its decision after I hear from both parties. Go ahead, sir. What are you asking for?
I'm just asking for my parenting time to get reinstated. DHS, the coordinator for the supervisor for the county or whatever, has came out here and Mitch Holdwick and I both contacted her, had emails with her, whatever, and she said that February, March of this year, there was a second home inspection done that was approved and safe, and that was for Ms. Kruger gave you those pictures, and those pictures were from over almost 2 years ago when I was building the porch on the front of the camper there, and it was approved.
That's the room you're in right now, sir. I'm sorry I interrupted you. Is that the room you're in right now?
Yes.
Okay.
And then Tanner has his own bedroom. He has his own bedroom with his own bed right here. He also has his own exit. You see it's an exit. It's right here off the ground. So I made sure that he's got a ladder right there. So there's an exit there. There's 3 exits in the camper, and there's 3 exits because I have an egress window also in here. I don't know if you can see. This one here is an egress window. And then this is a regular door. It's fully insulated here. It's just it's more space. Like I said, I have dogs here. I have a dog kennel here for the puppies and a dog here. But I mean, there's space for us to move around. It's been like, it's to accommodate both the dog and Tanner, so we have more space. Like I said, he's got a full shed outside for, he's got, 4-wheeler he got just this year, for in the summertime, a new bike, remote controls. I just purchased a bunch of, toys for him and stuff like, Discovery stuff, their pajamas, extra things for Christmas, for his presents and stuff like that. And we missed out on Thanksgiving. This seems to be an issue every year right around the same time. But the whole thing started over me asking Leonard Bradley for my pipes for my wood stove. I had borrowed him those pipes last year when Lucas moved back in with him, my oldest son, Davidson. Lenny got upset with me because he sold his fire wood stove with the pipes that I let him borrow, and then in turn got upset with me for asking for them and started calling me names and a whole bunch of explicatives. I never got back into that whole name calling thing or whatever. All I said was, I'd like my pipes. I still have your ladder. I would like to give him his ladder back, but I'd like my pipes back at the same time. And also, I let him borrow a larger 32,000 BTU he put 7 in his camper because he was living in the same situation with Lucas. I'm in right now also because we're both in the process of trying to build our own cabin, our own house. This whole thing is just it's a stepping process for me. I've got goals that I'd like to have a cabin here to leave to Tanner. This he helps me build these things. He goes to work with me. He learns things. It's a memory thing for him helping to build this place with me. You know what I mean? And then he gets to have it for himself because I'm trusting it all to him anyways. I'm sorry that
just a couple of questions here because we're kind of getting in the weeds here. In your motion, you have written, I've had previous inspections that were approved and he has lived here for 2.5 years. Both have lived and visited. I'm sorry, I proved that I've only upgraded. He has lived here for 2.5 years and visited. So you're telling the court that apparently DHS or DHHS did an inspection?
Yes.
Where's the DHHS worker? Because that's hearsay. I cannot consider an out-of-court statement.
Ann Schultz could pull that up. The email she sent the email over to the FOC stating that she does not have a subpoena to come and do another house check. That there's a file February, March. She specifically stated that in emails on text. Me and Mitch Holdwick both, and Mitch said just to file it. And I also filed for the actual file that they gave the court already back in February, March. So I'd have a physical copy of it myself. And
I don't have anything that might be in the FOC file. I don't have access to. I can't see it. And even if there is a report, I still need to have someone to either authenticate the report or to testify to say, hey, look, this home is sound.
She said, I understand that completely, Your Honor. Like I said, back in February, I got my suspension on my visits at that time, too. This happens recurringly, and I've only upgraded the place since then, and it was approved before I put all these upgrades on. When I didn't even have a door on the porch at the time.
You said approved, but do you have the inspector from Otsego County here to testify? Because again, that's hearsay.
She said she didn't have a subpoena and there was no reason for it to come out because there was never a complaint. And I said, well, the complaint I have now is that Tanner's being neglected and alienated from me once again for no reason. And she says, that's crazy. He comes up for a day, 2 days a month, and I'm not subpoenaed. I can't just show up to your house without a call for abuse, neglect, or something in that manner, or a subpoena from the court. That's her exact words.
Okay. Well, I can't render legal advice, Mr. Spencer, but I can tell you this. Either party is able to subpoena. They can prepare their own subpoenas and have these individuals even appear via Zoom. The court tries to be as accommodating as possible to out-of-town witnesses, out-of-town parties. We try to do that. And in your case as well. I mean, you're up in Otsego County, and the court is being accommodating to have you appear via Zoom. There are some courts that don't even allow that, but I do, and because I understand sometimes it's rather difficult, especially living far away. I don't have anything in the file to indicate that one, there was an inspection, two, that it's appropriate. Regarding alleged abuse or neglect, that's not before the court. The motion before the court that suspended your parenting time was the allegation that you were living in a trailer in Otsego County, camping trailer, and it wasn't fit for the child. That's what that is. And if it is fit, I need to have something other than you saying, I talked to these people and they said it's fit. You know, if I believe you on that, believe everyone, we wouldn't even have hearings. So I have to deny your motion, but this is what I'm going to do, though.
Ms. Schultz is
deny. Excuse
okay.
me. I can't look at Ms. Schultz's file. Ms. Schultz does not allow me to see the FOC file. There's a rule against that, and I can't see it unless it's properly admitted into the court file. So, regarding the parenting time suspension, the parenting time suspension will continue in part. I'm not allowing overnight visits. I will allow day visits, but that's it. Until we have something that the court feels comfortable that living in a camping trailer in the middle of winter in Otsego County is good for the child. That's what I need, and I haven't gotten it yet, sir.
Your Honor, it's in the file from February and March because I had to come back to court to get my visitation reinstated. At the time, I had to go and visit my son either at my sister's house or my mother's house or somewhere else. I have 2 Airbnbs right here that are not even 3 houses down from me, and one's a block off right on the lake here that I take care of. And both owners of the place that I could have my visits there if I needed to, that they didn't have a problem with it. I needed to be with my son, and that's just, they think it's tearing him up too because they've seen him all summer long living with me. And he comes.
Mr. Spencer, you're getting off track here. I have to look at what is before the court. What people say is one thing. What I have in front of me is another.
There's nothing in my file from February, March.
I have a couple comments on it. Mr. Spencer said he's getting his life together. We were here at the same time period. We both got sentenced in criminal court. We've both been getting our lives together for the same amount of time. He's been out of prison for 5 years. But his life should be together. This has all been on me. Everything. I mean, I'm to the point, I think I'm going to have a nervous breakdown or a heart attack. I don't know. He's calling me, threatening suicide when I don't send my son. His family is calling me. He just called me 2 days ago. Are you sending him this weekend? It's like, I don't know. None of this, Huron County investigated this, not Otsego. There's no reason Huron County couldn't be here. And he's leaving out that they don't want to contact him because he chased her out of his house. She fell in mud. She left her phone and had.
Okay, now we're getting the weeds with you.
I'm sorry.
But let me ask you this.
I'm tired of being blamed for his problems in here.
Please just listen to my question. If he has another place to stay, a home, I don't care if it's a mobile home. A mobile home is not a camping trailer.
Yeah.
If he has something that he can go to that is safe for the child and habitable for the child, do you have any issue with overnights?
I would want it to be verified and proved because for the last year I've been lied to about showers, about where my son's staying.
So if it's verified by someone that there's an alternative arrangement,
yes,
you would allow the parenting time to resume.
Yes, and I'm not opposed to his sisters either. I didn't suggest it in our last hearing because it's not me who's having the visits taken. So I don't mind his sister, but the problem is the dogs in all of these places. He can't take dogs, so his sister doesn't want the dogs there. I had before court even talked to her about it because I don't like to come here and do this. I like to get along. You have our message threads. I'm not trying to be spiteful. I just want to get along for my kid. I want my son to be able to play sports and him not say when he's mad. No, I want to be able to, if he wants to go an extra weekend, like, yeah, can he come with you? Yes, but I don't want to be the only one who's not, who's trying. I don't want to be in here every time with these reports.
For instance, if it's at sister's home, you have no problem.
I have no problem with
okay, let's go back to that. Mr. Spencer, is your sister's home available for weekend visits or whatever your visiting schedule is?
Well, it's supposed to be every other weekend in the holidays, but I haven't even seen Tanner in almost 2 months now. And
I wasn't asking that, sir. I'm just asking, is your sister's home available?
yes, my sisters, my mothers. Yes, my sisters, my mothers. Mr. Crone, he let me take my dogs there. I've got multiple places I could go, but this is the problem out of everything that I have is like these things that keep happening are a very big hindrance on my daily life and schedule, work, everything. Like I have to be close by. My sister lives 3 hours away. Like I said, I have Airbnbs that I maintain the complete property. So it's snow blowing, lawn cutting, cleaning, all maintenance, repairing windows, everything. I could do that right here. I could have the lady, she's a teacher down in Birmingham. She could write a letter or fax something over to the courts or whatever may need be to verify it. She'll allow it right here, and it's a fully insured Airbnb. It's 8 people. It's on Airbnb, Verbo, all the sites. Both of them are. They're very, very nice houses. $400,000 houses.
But your sister lives 3 hours away.
Very, very nice neighborhood. It's HOA. Yes.
I'm sorry. Your sister, you said, lives 3 hours away?
In Carroll.
Carroll. Where's your mom live?
Bad X. Not only that, I have my friend Scott St. John. He lives just 20 minutes away from me. I help out all the time with his daughter. He's got her all the time now to get to and from his meetings and things like that for her and things, whatever. And I could always stay there for the weekend with my dogs. That wouldn't be an issue, I'm sure. And that way I'd be close to home still, and I could still maintain work and plowing and maintaining all the contracts I have with people. So I have 9 people that I plow snow for. So if we get a snowstorm, it's on the weekend that, I have them, it'd be closer 20 minutes away than 3 hours away to try and get people plowed out for their own work and their own emergencies or whatever they have. We've already gotten 90 inches of snow since Thanksgiving, and we're already over halfway. It just started to be winter now. It's already over half our yearly amount.
This is going to be the court's ruling. Number one, I'm modifying my decision relative to day visits. The camping trailer located at in Johannesburg is off limits to the child for day visits or overnights, period, until we have a competent witness testify under oath that the home trailer camper is appropriate. However, overnight visits in a home, trailer home, and I mean mobile home, I'm not talking about a camping trailer. If there are alternative arrangements, an Airbnb, whatever the case may be, I'll allow the visits to resume. But if that child is with even a sniff of 3257 and it's brought to the court's attention, the court on its own initiative, the fancy word is sua sponte, on the court's own initiative, will suspend the parenting time immediately. So that means that, Mr. Spencer, you can have your overnights returned to you. However, it cannot be at 3257. It must be in a home that Ms. Kruger knows where the home is, and pictures, something that you can show her and to the friend of the court that it's a suitable place. Can you do that, sir?
Yes.
You understand that, Ms. Kruger?
Yes.
And
Does this start today then? Well,
when's his next visit supposed to be scheduled?
today.
It's probably too quick for that. What's the Christmas visit?
We haven't planned it yet because I didn't know.
What does the court order say?
It would be this weekend would be his last Christmas. He had Tanner the 25th of January 1st.
So it would start today.
His visit, his weekend, yes.
Not only that, last year
continue on the 25th.
Yeah, I get him the 26th to the end of the year this year then? We
Okay.
switched that, right? I'm sorry, I'm not really sure what it exactly.
I'll refer to the friend of the court.
Okay.
Defer to the friend of the court on that.
I do have a question while we're in here.
This would be the third Christmas that I've missed out on.
Just trying to figure out who has the visit.
Parties are subject to the 2016 Friends of the Court Parenting Time Guidelines. However, my laptop has died.
Kruger, you had the child the first part of the Christmas break?
Yes, he had him the 25th until the January 1st.
Okay, so his visit would start today through the 25th at 10.
Your Honor, I do want to verify that because that does not correspond to the guidelines that I'm following.
Okay.
My recollection is that this year, mother has the part of break and father has the second part of Christmas break, which is the opposite of what Ms. Kruger's indicating they did. So I just wanted to.
Okay, while you verify that, Mr. Spencer, is it your understanding that for the Christmas break, you get the first half or the second half?
Your Honor, I can't keep up. Every year she does this where I get my
you don't know
for some reason. So I can't tell you because I haven't had them for 3 years for Christmas. I had to do Christmas like on the 9th at my sister's last year of December, and I didn't get to see him at all. And the same thing with your court because wherever I seem to be, there's always an issue with where I'm living or who I'm living with or.
Well, the court doesn't bring the motions; they're brought by parties. Mr. Holbrook,
Right.
Did you chime in on this? I saw your screen pop up here.
No, I didn't, Your Honor. I just, my computer was about to die. I had to quick plug it in, so.
Everyone's computer's dying.
I do have, if it helps, the message the day I dropped him off last year, I screenshot. And the day I picked him up.
Well, let's just look at the order.
According to the 2016 guidelines, mother in an even numbered year has the first part of Christmas break. So 3 o'clock today, today's the day most of the districts recess, until 10 a.m. on Christmas Day. That means father is entitled to the second portion of Christmas break, 10 a.m. Christmas Day through the Sunday before school resumes at 6 p.m.
Perfect. So that's what we're going to do. I'll reinstate the parenting time only when Mr. Spencer provides to mother and to the friend of the court where the child will be for the second half of break. That has to be provided. Well, no later than Monday or Tuesday. We're closed on, it has to be Monday. You have to get that to us by Monday, what the proposed plan is, Mr. Spencer, where the child will be, where you'll be, and if it's suitable, beginning on the second half of the Christmas break, that's your time with the child.
Mr. Holbrook's in there right now. He, I believe, spoke to the MDHS lady just last week and got the, what do you call it? Did he chime in on what he received on emails and stuff that I had directly forwarded over to him?
You're beating a dead horse, Mr. Spencer. Whatever Mr. Holbrook tells me is hearsay as well. I need it from the horse's mouth.
The emails that the horse's mouth sent over would be not verification enough?
No, that's hearsay. It's an out-of-court statement to prove the matter asserted. And that I cannot consider that. You raised your hand, Ms. Kruger.
I did have one question. On his weekends, I mean, it's going to switch now because Christmas, but he has sports. Well, he has basketball every Saturday. And I'm cool with the 2 Christmas practices being missed, but he has stated to me he was cool with it before this started. When I filed the motion, it was Tanner doesn't need to play sports now. So we agreed on it already, but now he's going back and saying he doesn't want him to go, and it falls on his weekend. So
then you're going to have to file a motion on that.
Okay, and
you're going to have to file a motion because the general rule here is when it comes to extracurricular activities, when the other parent has the child, That other parent can take the child to the extracurricular if they want to, or they don't have to.
Yes, I've seen that.
So you're going to have to file a motion to address that. But I'm going to resume the parenting time so long as it doesn't involve 3257.
How do I find out if it was submitted and if?
I ordered that the photographs and the information not only be provided to the friend of the court,
Okay.
but also to you.
Okay, so I don't have to wait for a friend of the court. They won't be here Monday, but.
Oh, they'll be here Monday. They won't be here Tuesday.
Oh, Tuesdays. Do I have to contact anybody or I just send them and don't worry about any of the other?
Well, just stay in contact with the friend of the court on Monday.
Okay.
Your Honor, just to clarify, because the parties do tend to reach out to either Mr. Holt or myself directly, they will need to speak to a staff member on Monday, and they will need to use the general email account.
Did you hear that, Mr. Spencer?
No, I didn't.
Normally, each of you may reach out to Mr. Holdwick or Ms. Schultz. None of them will be available on the 22nd, 23rd. So you're going, if you want to send something, you have to send it to the general email address of the friend of the court.
Okay.
You understand that as well, Miss?
Yes.
What's the email address? So they know it.
Huron, FOC@co.huron.mi.us. It is also listed on our website.
Okay. Huron FOC, all lowercase, no spaces, at co.huron.mi.us.
Okay, and then just send the pictures to that and then send
that address and to Ms. Kruger, CC
Okay.
Ms. Kruger, and not only pictures, but we need to know the address and what the plan here is.
Okay. Now can I ask you another question?
Wait, let me hear from Ms. Schultz first.
I would ask that if it's a residence belonging to a family member or one of the Airbnb, that there be documentation included as to whose residence that belongs to, with a letter from the owner, a letter from the family member, so that we have adequate information.
I agree. So if it's an Airbnb, you have the permission to be there. They're authorizing you to be there. It's just crossing the T's and dotting the I's.
Not only that, can I leave the address and the person's name out for Nicole not to get a hold of, because she likes to call the HOA president, and it's already been documented that there's an order where she can't be doing these harassing things. She's got me fired from multiple jobs, kicked out of multiple places, and been vindictive in a way to manipulate people to just not want to deal with it, and this has been going on for 9 years. And there was an app close document. I just don't want to have other people harassed because of.
I'm not going to order that, but if there is harassment and there's something brought up, you bring it to the court's attention and I guarantee we'll address it. There's no need for that. All we need to do is that the child's in a safe environment and that it's suitable for a young child to reside, especially in Otsego County during the winter. That's all I care about. And if it comes out that there's harassment or something else going on, we could be talking potential contempt and jail time. I don't want to go there. By golly, folks, it's the holiday season and it's now time to step up.
Thank you. I've been just trying to, that's what I would do, is just do the best I can for him and give him the best that I can afford and can I do. Yeah, I messed up my life, but I'm not trying to leave that legacy to him. I'm trying to break that whole cycle of in and out of jail, drugs.
Let's move forward. Let's move in a positive light. We'll move forward in this matter. And if we don't get the documentation on Monday, parenting time remains suspended, or will be suspended, I should say. We need to have it.
Okay.
And that's how we'll proceed. Good luck to you, Mr. Spencer. Good luck to you, Ms. Kruger. This is Ms. Gabrielle's motion regarding parenting time. She is in the courtroom. She's in pro se. The defendant, Mr. Kaster, appears via the Zoom application. Will you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes. Thank you. You may put your hands down. Ms. Kaster has motioned the court to suspend father's parenting time. In part, the motion reads, I'm asking the court to suspend Sorry?
Caldwell?
Ms. Caldwell. I apologize. You are right. Ms. Caldwell has filed a motion asking the court to suspend visitation from father to daughter due to the fact that he's currently in jail for another domestic violence against me. Also, I'd like to ask if the visitation is somewhere else or a public place. Currently, they are at Caden's mother's house, and I believe that is not a good environment for our daughter. Another individual is in jail for home invasion. She was recently in jail for a drug charge. Therefore, the petitioner believes it's the best interest that visitation weren't held. Ms. Caldwell, is that what we're talking about here?
Yes.
Okay, what is the parenting time order currently?
Currently, it is supposed to be every other weekend at his mother's house, which currently he's in jail right now, so like if he doesn't get visits. I don't know if it's in there or not about if it's supposed to be supervised or not, but I would like for them to be in the future. But the reason why I was asking for them to be suspended is because my CPS worker advised me.
Okay, that's hearsay. That's what I just had in the previous hearing. Do you have the CPS worker here? Okay. Mr. Caster, is your case pending currently? Is it over? What's the status of your case?
I gotta wait till January 2nd to be, that's my plea cutoff date.
Okay, so it's pending.
Yes.
Okay. I don't want to delve into the allegations. All I know is that according to the motion, it pertains to an allegation that there was an assault upon Ms. Caldwell here.
This is the second assault. Awesome.
Okay, well, the charge is currently pending. What is your bond currently, sir?
$25,350.
And the matter is scheduled for a plea cutoff in early January?
Yes.
Is there a trial date?
No.
No trial date.
Can I just make a note also that he was holding and he had my daughter, like he was holding her the whole time that he was assaulting me.
Okay.
And that's in the police report.
Okay, well, I don't have a police report. I have no idea. All I know is that you're asking that parenting time be suspended. Mr. Caster, do you believe you'll be able to post bond prior to trial in this case?
I'm hoping that they'll give me time served by January 2nd because I'll already be in here for 41 days. And my max that they can give me either way is 90 days.
Okay, just a moment. Court's going to take a look at the records. Court records, which are not yours. Maximum jail sentence to a year in the county jail. Domestic violence first is a 93-day misdemeanor maximum. So there's a potential that if the defendant were convicted, and I don't know anything about the case, it's not my case, he could serve up to a year in the county jail. Now, his bond, he has not posted his bond at this point. There is a plea cutoff date, early part of January. Doesn't appear to be a trial date at this point. So at this point, what the court is going to do is suspend the parenting time for father as he's currently lodged in the Huron County Jail. Once he is released from the county jail, he can file a motion with the court to reinstate parenting time. And the court will hear that matter as quickly as possible. But it will take a motion that you'll have to file, Mr. Caster, with the court. You understand that?
Yeah.
Okay. Thank you. So parenting time is suspended for father. Once he is released from the county jail or has an idea when he's released, he can file the motion. The court will hear it to potentially reinstate parenting time. Do you have any questions?
When he gets the parenting time back, could they be supervised?
We'll address it when that time comes. Mr.
So
Casey, do you
I also have
any
a question. Yes. So I'll be moving from my mom's house, so I won't even have her as a third party anymore after this is done. So I was wondering if I could change that third party to somebody completely different.
Well, we're not going to put the cart before the horse at this point. Once you're released from the county jail, we'll hear the arguments as to where you are and how potentially we move forward. I can't make that decision yet. I can only look at what's in front of me right now.
Okay.
Okay. Thank you. That'll conclude the proceedings as well. Off the record. This is the defendant, Mr. Rundell's motion for custody, parenting time. Sounds like there may be a show cause hearing as well. And there's a motion regarding the child meeting court. Both parties are present in the courtroom. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do. Thank you. Before we proceed in this matter, could I hear from the friend of the court?
Your Honor, an order of support had entered on November 6th of 2012, that order granted Ms. Jimkowski physical custody of the minor child. It did not address legal custody. And parenting time was awarded to Mr. Rundell pursuant to the 1997 Friend of the Court parenting guidelines. It's my understanding that the parties may have resided together following entry of that order. There's a number of complaints that have been filed with our office, which has resulted in the show cause proceeding. And it's also my understanding that there may be criminal charges pending with the district court at this time.
Thank you. And the court does try to do its research before we hold these hearings because I at least want to be informed as to what's going on. The court took a look at its own records. And as I understand it currently, there was a plea previously to domestic violence with Ms. Jimkowski as defendant. Currently, there are 2 counts of aggravated stalking pending in the district court. However, that matter is on hold because there's a request for a competency evaluation.
Yes, sir. I was in a bad car accident some 24 years ago.
Oh, I understand. And so when the issue of competency comes up, obviously that piques the court's not curiosity, but concern, because the idea is whether we can proceed in a matter like this.
Of course.
So.
I can explain if you'd like.
Oh, no, I don't need any explanation at this point. I just want to make sure that we're doing what's best for this minor child. How old is the child, sir?
13.
Okay. And what are you asking for? And please don't use the child's name.
What I'm asking for is temporary custody of my son till she does her evaluation to find out whether she's competent or not, and for her to have supervised visitations.
And what's the reason for the supervised visitations?
Because with her head injury, she becomes easily hostile. She's physically, mentally, and emotionally abusive.
When was the head injury?
In August, I believe, 19th of 2000.
29.
August of 2000?
I believe so.
So from the order here in 2012 through 2000, no issues, correct?
None that I reported, Your Honor.
None that you reported. Okay. What are you alleging that occurred from August of 2000 forward that you believe there's proper cause or change in circumstance to warrant the court reviewing custody of this case?
Since she's had my son, she picked him up on November 13th from school. Never brought him back to the house. Since then, there has been an incident where she slapped him on the leg. I have text messages where she referred to him as he's nothing. She's also referred to him as, he told me that she referred.
Okay, we can't go to what the child said.
All right. Well, I have in the text message, but.
Right, but so you're stating that you have not seen the child since November 13th of this year?
No, I have. As a matter of fact, today is my visitation day, my weekend.
And I have a problem with that.
Oh, okay. Just I want to hear from Mr. Rundell first.
No problem.
No disrespect. So, but my question is, since the traumatic brain injury as a result of a traffic crash, what is going on that you feel that the child should not be with mom and should be with you?
Because of her hostility, because of her actions when she gets angry.
And you've seen this firsthand?
Yes, she's assaulted me several times in the past, and she has assaulted me several times in front of my son. And I failed to report it. Finally, on September 7th, I believe it was, I went ahead and turned her in for assault for 3 days in a row that she assaulted me.
And is that the matter that resulted in a conviction of Ms. Jimkowski for domestic assault?
Yes, it is.
You've seen your son, obviously.
I have.
And can you describe to the court, without telling me what he said, what you've observed regarding your son as to how this may have affected him?
He's become very angry with his mother, mother. He doesn't want to be around his mother. He's clamming up. I get him to talk to me when he comes to the house, and he opens up with me and tells me that he don't want to be around his mother. That's why I also, I hope I'm not speaking out of turn, but that's why I motioned the court for my son to speak with you, Your Honor. And he asked me if I would arrange
And
that.
I see that he's 13, correct?
Correct.
Anything else you want the court to consider before I go to Mr. Kuski?
No, not at this time.
Okay. Mr. Kuski, this is your opportunity. What would you like to tell the court?
Overall, a main problem I have is this defendant or plaintiff, whatever he's called, feels it's appropriate to, allow my son to hang around murderers and rapists. I don't think that's appropriate for my son. And
13-year-old?
yeah, my son was the one that informed myself and my mother.
Okay, well, we can't talk about what the child said.
Well, I find it non-substantial to allow my son to be made that he has to feel comfortable with such criminal intent, murder and a rape.
Okay, so
And
who
I
are these
was
alleged murderers or rapists that he's around?
Leroy Boyer with my
I was
daughter. She'll be 19 on the 22nd, so I have a problem with being around rapists, and I don't feel it appropriate that my son is told to be made comfortable with this specific person. This specific person has also driven my son to doctor's appointments. This specific person has brought Terrence to pick his son up. The first time he had visitation, he wasn't there for a good hour, hour and a half. And within that time, I had things I needed to get because I am just now moving into a new apartment for my son and I needed to get things for the apartment. And we got met outside by the police for him to get visitation. My other question is, because he does not have a driver's license, is it inappropriate that he picks the TAP bus up? The TAP bus brings him to Port Crescent Apartments, where he would pick our son up and the TAP bus could take them back home. So my son is not around this criminal, which he is also. Terrence, James's father, is also a criminal because he spent a good year and a half in Jackson prison for drinking and driving. He is also, from what I understand, trying to get his driver's license back. And also from what per se people tell me that I don't care.
No, I can't go into what
Okay,
other
that
people
he
have said.
has a drinking problem recently also. Supposedly.
Okay, I can't consider that.
Okay,
I can't consider that.
Okay.
But, okay, so the primary concern is this
the
Mr.
safety
Boyer,
of my son, yes.
correct? Okay. How do you respond to the allegation made by Mr. Rundell that the domestic violence at which you pled guilty to or found guilty at trial had your child there at the time?
He was not there. Is that what you're asking?
Yes.
He was
So
not
you're
there.
saying he wasn't there
He was not, he was with my mother and her boyfriend at his cousin's birthday party.
but he says child was there.
And he's lying because he was not. Guaranteed, I can prove it.
The day she was arrested, I said a week prior, at least I thought I said that a
Yeah.
week prior.
Okay,
It's
so
all lies.
we're not. This is not a kangaroo court. There's decorum that the court has to follow. So I misheard them. So you are stating that you are alleging an assault that occurred that was not charged,
Correct.
where your son was there
He witnessed it several times, yes.
several times,
Yes.
and you deny that.
I do.
Okay. Well, the court finds that there is a change in circumstance warranting a review of the custody factors in this case. As the change of circumstance is the allegations of domestic assault. I'm not saying they are happening. I'm not saying they're not happening, but there is a conviction for domestic assault. Currently pending are 2 criminal charges against Ms. Jumkuski, specifically for aggravated stalking. Both of those are currently in limbo at the district court level, not because of what the district court did. They're doing their job. It is a matter of competency to determine whether or not Ms. Jumkuski is competent to stand trial. Now, the court has heard statements that domestic assault occurred around the child. One party says it did happen. The other party said it didn't happen. This child is 13 years of age. And regardless, I find the change in circumstance warranting the friend of the court to do an investigation relative to custody, parenting time, and support. And what will be required of each of the parties is that each of you will have to submit documentation and or meet with the friend of the court to sit down. They're going to be asking you a number of questions. They'll give you forms to fill out. You fill out all that documentation, and then they will compile all that, put that together for a friend of the court report. The individual pictured behind you is the individual that will be conducting the investigation, more than likely Mr. Holway. The question is now, what do we do with the child? The child is currently residing with mother, correct?
Yes, sir.
And Mr. Rundell, you have the alternate weekends of parenting time?
Yes, I did.
Okay. And you've been engaging in those visits, correct?
Yes, sir.
Okay. Ms. Jimkowski, what is your thought about the court meeting with the child?
I have no problems with it, but I will tell you, I have noticed, okay, James usually he's upset with me usually.
But let's not mention the child's name. But go ahead.
Okay, my son is usually upset with me before he goes. So we'll say it starts Thursday, and then he's leaving, supposed to go today at 6. And then when he comes home Sunday around 6, it's like I have to work him down in the sense, see, he's fed a lot of mistruths, we'll call it, from his father and all of his friends, every one of them. There's like 5 maybe.
The court can definitely sift through that.
He comes through and he treats me different just because of what his father and his friends have told James, or my son, sorry, all weekend. And then my son asked me why he finds out all these lies. And I tell him, I don't know, James, believe what you know to be true. And he thanks me for giving him a good place to live at.
Well, we're kind of going beyond the scope here. Mr. Rundell, what's the story regarding Mr. Boyer?
Mr. Boyer, to the best of my knowledge, 17 years ago, was in the wrong place at the wrong time. He was in a vehicle, and someone that was with him committed a crime where he had hit a elderly woman, and while she was in the hospital, she got pneumonia and died. And Mr. Boyer was charged with an accessory, to the best of my knowledge. Mr. Boyer has not been alone around my son at all. I am with him. He has given me transportation to pick my son up for visitation and to take him home. And the reason that this occurred is because I have a police report here from Sergeant Brad Strozeski that I tried to get Tat to pick him up 3 different times that night. And every time that I would get the bus set up, she would grab my son and go somewhere else. My son called me and said, hey, I'm at Myers with my mom. And I said, fine, I will call for a civil standby. It was Brad Strozeski that showed up. And when they came out of the store, the only ride I could have at the time was Leroy Boyer. And Officer Strozeski let her know that it was my visitation. He was allowed to get in the truck and leave with me and Leroy.
Okay, so
several times.
So my question to you then, sir, is Palm Transit available to you?
Yes, sir, it is.
Okay. And the child is 13 years of age, so this is not an infant walking to and from bus.
Correct.
Okay, well, I need to speak with the child.
I understand.
And the reason the court wants to speak with the child, because that'll give the court a better understanding as to where we are in this. Now, I can be honest with you. There are some times that I've met with children and they sit down and speak, and they're very great young people. Sometimes they're being honest and sometimes they're not. But the court is trained in that. Mr. Holbeck is definitely trained in that. So is Ms. Schultz. And we can get to the point here of what's going on. I mean, we're not soothsayers where we can say, hey, you know what, I know exactly what happened. We can't do that, but we have a good understanding. So this is what the court will do. Number one, on an interim basis, all transportation regarding the minor child, unless it's a properly licensed driver other than Mr. Boyer, and I'm not judging him because I don't know much. I wasn't even in the area when this allegedly occurred. But for the safety of the child, Thumb Area Transit is appropriate. If there's another means of transportation that doesn't involve Mr. Boyer on an interim basis, so be it. So if it's a properly licensed driver and the other party has notice of who it is. So for instance, if you have another friend, we'll just say Mr. C, and Mr. C is a good individual. All you need to do is let mother know. Mr. C will be picking up, or unless you're with Mr. C, or public transportation, either way. By doing that, then the parties are on the same page regarding communication. Now, how do you communicate with each other?
We don't.
That's why I was just gonna tell you
That's
there's a problem because there is a no contact order.
Oh, yes, because of the ag
Which
stalking
also
charge.
violated this a week and a half
My
ago and
next-
sent me another text that has not been opened.
My next question is, he's always calling a friend of mine and harassing. He's always sending nighttime checks. My son has even spoken to a police officer. I'm not sure exactly who it was, but I know he had asked that his father stop sending wellness checks because he has school early in the morning and Terrence sends him out between midnight and 2 in the morning to do wellness checks. And in turn, I have to wake my son up to talk with the police. So then he gets that much less time to sleep and he's tired for school the next morning.
Well, there must be some reason for the wellness checks. I don't know.
He's right there. You gotta ask him.
But,
I'd love to do a wellness check at his house to prove him drinking all the time.
Mr. Chukowski, hold on here.
Sorry.
I mentioned Mr. Boyer on a temporary basis is off limits. I'm going to meet with the child. I'm hoping they finish school today.
He gets out at 11 today, half a day.
Will you have the child on Monday normally? Will you have the child normally on Monday?
Oh, yeah. Monday through, yeah.
Oh, good.
Interrupt for a moment, Your Honor.
Just 1 second, sir. We just want to schedule a date.
It just seems like Terrence even has time to take care of himself.
10 a.m.
Yeah.
That's the swearing in. All right. I'd like to meet with the child 11 a.m. on Monday. Can that be done?
Here?
Yes.
Okay, 11 a.m. on the second floor.
Yep. Second floor. You just check in with a friend of the court's office, and it's going to be me. It's going to be me because I know you're not available, but I will. I'll ask the court administrator to join me. Or if there's another member from the friend of the court's office you designate, that's fine. Either way is fine.
Perfect.
I want to meet with the child at 11 a.m. At this point, I'm not going to change custody until after I speak with the child.
Thank you, Your Honor.
After I speak with the child, the court will issue a ruling. And that ruling will be a temporary ruling, and it will continue until we have the custody documents prepared, or the custody recommendation prepared. And that's not only physical custody, but legal custody as well. We need to establish that. So custody will be looking at physical and legal custody, parenting time, and support. Prior orders will remain in effect currently. So I'm not changing anything until after I hear from the child. After I hear from the child, I'll issue a written ruling. Both parties will receive it, and I'm going to do it that day.
Will I find out if there's any changes or anything?
Oh, absolutely.
That day?
Yep.
Okay.
Yep.
Do I
Absolutely.
need to like make a court appointment or anything?
Nope. Nope. But we need to figure out here, what in the world do we do with communication with no contact?
It's actually working great for me.
My understanding is normally the district court will modify bond provisions if this court orders applicable, but that would have to be put on the.
Sure. Do deference there. Do you have a smartphone, miss?
I do.
Sir, do you have a smartphone?
Yes, I do.
Wonderful. Court is going to order AppClose, APP space CLOSE. That is a free application designed for parents in situations just like this where they communicate. And when they communicate,
I don't feel comfortable communicating with them.
well, it's,
That's all I'm saying.
well,
Okay,
here's the thing. If you don't communicate, we're going to have a problem. You can't communicate right now anyway.
right.
This order is only subject to the district court allowing this to happen.
Okay.
I'm giving deference to the district court because there's a criminal proceeding that's pending, and Judge Harrington said no contact. If there's no contact, there's no contact. Ms. Schultz is right. There are certain situations where there's a minor child involved, that when the minor child is involved, they make accommodations for that. So I'm just ordering the application to be installed on your phones to utilize. Ms. Schultz, is this something you can bring to Judge Harrington's attention?
I can, I would assume, I'm not sure if Mr. Petsky would be assigned to Mr. Asintasky or Ms. Wood at this point, but we can absolutely make contact with the district court to inquire.
I believe I've spoken with Mr. Osinowski.
Okay, so don't communicate with each other at this point. Just install the application. If there's an order that comes from district court modifying the bond condition to allow contact by app close only, that's great. If not, there's no I can't order the communication because it'd be a violation of your bond condition, and then you could be lodged in the county jail.
Of course.
So that's what we'll do. You have this weekend with the child?
Yes. Can I interrupt for a moment?
Sure.
Can I ask, Mr. Schmerich, if you don't mind, if it'd be all right if
That's the other problem.
if he would be able to pick my son up for visitation and drop him off Sunday after visitation?
That's Mr. Ronald Schmerich back?
Yes, it is. Yes, it
Your
is.
Honor, before you ask that question, it seems the parties are not aware that Christmas break parenting time begins today. They're referencing alternate weekend schedule. However, holidays take precedence over the weekend schedule.
Even under the old
Even
1990s.
under the 97.
So what does father have then?
I would ask Mr. Holdsworth if he can pull up the 97 guidelines. I have no power on my computer at the moment.
Give me
Can
one
you pull the
second.
97 guidelines?
Yes, I can.
I know it's still alternate years, plaintiff and defendant, but I don't recall him looking at the exact schedule.
Yes. Yeah, okay. Thank you.
The courts want to know what the first and second half schedule is.
Yes, please.
Christmas school vacation is 6 p.m. The day school recesses until 6 p.m. the day before school resumes. Even number years plaintiff shall have the child for the first portion of Christmas vacation until December 24th at 10 p.m. and defendant shall have the minor child the second portion. Odd number years, defendant would have the first portion, plaintiff would have the second portion.
So mom would have the Christmas break first until Christmas Eve at 10 p.m.
She's plaintiff, yes. And so it'd be 6 p.m. the day school recesses until 10 p.m. on December 24th.
So then do I get him today or just?
According to the order, you get the child today, but I have a question. You're recording this.
What's that?
You're recording this with your phone.
I am?
Yes, you are. Hand the phone to the court, please.
Okay.
There's no recording in the courtroom in any way, shape, or form.
Can I further explain?
No, I don't want any explanation. I want the phone.
Yes, sir. I
You
do
need to
have a
unlock it.
doctor's script, excuse me?
You need to unlock the phone.
Oh, it shouldn't be locked. I don't think I have a lock.
New recording.
What?
New recording. New recording.
Yeah, they're all saying new because I don't have none of them labeled.
9:03, 9:45, 10:25, 10:57, 11:07. You're recording these proceedings?
I was trying to record mine, this one.
Yeah, you're not allowed. Did you see the sign on the door?
I did not.
I find you in contempt. Have a seat.
What does that mean?
Just a moment. Court reviewed the phone. The court administrator reported to the court that the plaintiff is recording the proceedings in the courtroom. There is a sign that says there's no recording. The Michigan Supreme Court has authorized parties to utilize their phones when it comes to proceedings, but not to record proceedings.
Okay.
I find you in contempt for violating the court rule relative to that. Is there anything, Ms. Jimkowski, you'd like to say before the court imposes disposition, which could be up to, court could include jail time. Anything you want to say?
Yes, sir. I have a closed head injury. I have trouble remembering. I have documentation. I can get documentation if need be. Because of those injuries, I have a hard time remembering. Per se, the doctor described it. When my head brain hit the inside of my skull, it leaves dead bruises all over my brain. So I have a hard time remembering.
Okay, I understand that, but when you're downstairs in district court, in the criminal charges you're currently facing, you're recording those too?
I don't believe so.
Well, then how is this any
I have a hard
different?
time remembering.
I understand, but do you record the proceedings when you're in district court?
I don't believe so, no.
You don't believe so? Well, I know for sure you're recording these proceedings. The court could hold this phone and confiscate it. You want the court to do that?
Well, not necessarily, but if need be, by all means. I was just doing it for myself because I have a hard time reading my handwriting because I have nerve damage
I
from the
understand,
accident.
but the point here is it's not to be recorded. If you wish to have a transcript of the proceedings, that's why we have Ms. McNames here. as
I've been
Deputy Court
trying to
Administrator.
raise my hand, ask for a transcript, but I forgot what it was called.
Okay, no problem with that. I'm going to fine you $100 for violating the court order. You are to provide that $100 fine to the court no later than January 3rd, 2025.
And how much, 100?
$100. No further sanctions will be imposed. Don't let it happen again.
Yes, sir, sorry. It was my misunderstanding, I guess.
So back to what we were saying. Mom has the child now through December 24 at 10 p.m. After that, father has December 24, 10:01 p.m. through the end of the Christmas holiday. Up till Sunday before school.
Most of the districts are going back on January 6th. However, I don't know the child's district because some are going back on January 2nd.
I think he is.
When does the child go back to
I
school?
believe it's January 2nd. He goes to,
I don't know.
I don't know their schedule either.
from what I understand, it's January 2nd.
I can look that up real quick, Your Honor.
Okay. And while you do that, what's the objection to Mr. Shimerick?
See, my son gets told all kinds of lies about myself from Terrence, his friend Leroy, his friend Ron Shimerick, and his coworker Josh, and Josh's wife Star, who has since gone through my house and has thrown my personal possessions.
Okay, I've heard enough on the issue. I have no objection, and I'm going to allow Mr. Shimerick to be a transporter, so long as he's properly licensed. That's all the court cares about, and insured.
Can I file a
And
motion?
you could file any motion you wish, but I'm going to allow that. But I will trust that Mr. Shimerick will not be talking about anything other than pleasantries
My son is.
and that relative to the child.
My son-
Mr. Shimerick is in the courtroom. Mr. Shimerick, do you understand that, sir?
Yes, and that'd be interesting. I know it can't be, but it'd be interesting to see what his lies have been telling. That's not my thing to do that.
There's been lies.
Well, yes, I don't need the commentary. I don't. So Mr. Shimerick understands that. The court is familiar with Mr. Shimerick. And if there's a motion that you wish to challenge that, you can go ahead and the court will hear it. But I find Mr. Shimerick to be appropriate for transportation.
Thank you. I just thought it'd be appropriate that Terrence could schedule his own ride to pick up his own son.
I don't need the commentary anymore.
I'm sorry, I'm sorry. I apologize.
Your Honor, I was able to find that date when Lakers goes back to school.
What, sir?
They return back to school the same as the rest of the district, and their first day back to school is Monday, January 6th.
So what does that mean?
Through Sunday, January 5th, Mr. Rundell is entitled to the second present rate, beginning 10 p.m. Christmas Eve, Sunday, January 5th at 6 p.m.
I have that written down, please.
That's the order. That's the order.
I'll get it.
That's the order that's in the file.
If you want a copy of the holiday schedule, that's available from the.
Yes, please.
Yes,
We'll get
please.
that.
I need one also.
We'll get it to both of you. Okay, in the meantime, while the child is with mom up until the Christmas Eve at 10 p.m., Well, not only that, but more importantly, for the meeting on the 23rd, the child is going to be inquiring, what am I doing? I'm talking to the judge. All you can say is you're going to have a meeting with the judge and that's it. No inundation by anyone or anything about, well, you need to say this or you don't need to say that. We can figure that out if that happens. The bottom line is I want to hear this child and hear what this child has to say, and then the court can make its determination after that. Do we have an understanding? Rundell. Ms. Jimkowski, do we have an understanding?
That's at 11 o'clock on Monday.
Yeah, but do we have an understanding regarding talking to the child?
Yes, sir.
Wonderful.
The word.
Thank you. That's it.
Your Honor.
Yes, sir. Go ahead.
There is still the matter of the show cause against Mr. Rundell for alleged denied parents' time.
I'm sorry. Go ahead with that. I apologize. Go ahead.
We had received a written complaint with the numerous issues from Ms. Jimkowski. And one of the statements that was attached to show cause stated she tried to pick the minor child up from Mr. Rundell and he denied her. There's no specific dates that she was able to provide, I believe, given her injury. But my understanding is that the child for a period of time was with Mr. Rundell and not going to see mother, and which is why the complaint was filed. Now, from hearing today, I understand that the child's been back with mother, but there was a period of time, to my understanding, that the child was with father and not with mother pursuant to the court order.
And that was regarding alleged denial of parenting time on September 14th of this year?
Correct.
Bless you.
Bless you.
Take a look. Okay, so Ms. Jimkowski, we're not done yet. You're alleging that Mr. Rundell did not give you the child back on September 14th?
I didn't have him at all through September. I believe it was 2 to 2.5 months. Terrence was holding my child from me. I couldn't talk to him. I couldn't see him. I couldn't visit him. That is also, I believe, when he tried to turn me in for stalking.
Okay, so what's the time frame then that you claim that you didn't have the child?
I didn't have my child for a good 2 to 2.5 months after Mr. Rundell sent me to jail in the early part of September.
So were you in jail all that time?
No, I was in jail overnight and then I was forwarded to a friend's house. I've been staying with a friend or in my own apartment since. But Terrence was keeping my son from me. I couldn't see him. I couldn't talk to him. I could have no contact for no reason. But he
So
was
how many days are we talking?
like 65 days, 67 days.
Your Honor, if I may just add, this complaint came into the friend of the court's office on November 14th. So friend of the court policy for makeup parenting time is that we can only go back 56 days from the date of complaint.
You require me to do math here, aren't you?
I am.
Like I said, I'm not real good on days and numbers because I have a head injury, but I've already made it past all that and I've proven to get my rights back several times.
So we wouldn't be dealing with,
My rough math says that the earliest we can look at would be the beginning of September.
that's where I was going to. And it appears that the note that was sent, apparently this is from Ms. Jimkowski, Saturday, September 11th, went to jail, September 14th.
Oh, I had the wrong dates on there. Because he sent me to jail in the first part of September, sir.
All right, well, we're coming back on this. The court's going to preserve the issue.
Can I speak for a minute, Your Honor?
I was going to reserve it, but go ahead.
I'm sorry.
No, sir, go ahead.
I was just reading the same thing, and I'm just saying that she was saying she was not allowed visitations, when it says right here she was. And the only visitation that she didn't get was when her boyfriend,
I don't have a boyfriend.
Dave, called the house
It's the one.
asking if she could pick him up for a visitation, and I had it on speaker, and I looked at my son, and I said, would you like to answer that? Do you wanna
Oh,
be with
you
my-"
can't talk about this, what the child said.
But I'm just saying. she
There are notes here regarding Dave. I do see that. Says, September 14, Dave called to Terrence for me to get Jane, child, and he would not let me have child. He said I was violent.
Yep. He's the one that told James I hit James. James didn't even know I touched him.
I'm preserving the issue. The issue will be addressed by the court once after the front of the court recommendation is out. And I'll preserve the days, but I don't see 50. When did you get the child after all this stopped? After you claim you didn't see the child, when did you get the child back?
Oh, I don't have a specific date. Me and dates don't get along, I suppose. Keeping track of them, that's my downfall.
But your notes indicate that you picked up a child from school on September 19th.
Yeah, I was picking him up from school and driving him home a few times, but that was it. I would pick him up from Lakers and I would drop him off by the road or at the corner. Yes. And then Terrence here would sit out on the deck on my patio furniture, and then he would threaten me. He followed my mother into her doctor's appointment, and even the nurses felt threatened by his presence.
Hearsay?
You have a
He was
response?
also there with Leroy Boyer.
We've already addressed that. Your response to this, sir.
My response to it?
Yeah.
Her mother was at the doctor's office. Me and Mr. Boyer was already there for his wife's doctor's appointment.
Let's just focus generally. How do you respond to this alleged allegation that you denied for custodial? In general.
No, I did not. One time.
Excuse me, Mr. Jimkowski, I'm not speaking with you at this point. I've been very respectful, and you've interrupted countless times.
Sorry.
Go ahead, sir.
The one time when Dave called my home, asking if she could pick him up, and I asked my son, do you want to go with your mother today?
Okay, I don't want to hear what the child said.
All right.
The court's making a ruling on this. Show cause is dismissed. That'll be all. Thank you.
Thank you, Your Honor.
Off the record.
You all have a Merry Christmas.
You too.
Thanks.
Yeah, we're going to give you your phone.